All right, good afternoon, and welcome back for our final segment of the George Mason Law Review 29th Annual Antitrust Symposium. It's a delight to have all of you here. For those of you I have not yet met, my name is Donald Koshin. I'm the Executive Director of the Law and Economics Center and a professor here on the faculty at Scalia Law School. This is a wonderful event that celebrates the achievements of the students in bringing together their annual symposium, and it integrates key faculty members, including this year some of the principal organizers being Professor John Yoon and Professor and Judge Douglas Ginsburg, who were instrumental in putting together the program for this event, and I thank them all for their contributions to it. I also would like to thank our sponsors, including the Antitrust Education Project, DCI, and FTI Consulting for helping offset some of the resource commitments that were necessary for this program. As you may know, the Law and Economics Center is in its 50th anniversary. Well, we just passed our 50th anniversary. Started in 1974, and we provide all of our programs as a public service. That includes programs that we do that bring in about 650 judges every year on average to a variety of programs we hold across the year. We have about 150 to 200 state AG attorneys that come through our programs every year, hundreds of academics, and then the entire public for programs and forums like this. So we're delighted that all of you were able to join us in the mission of the Law and Economics Center to increase the understanding of economics and its application to law. We're also delighted that you get to come and visit us here at Scalia Law School, which is a constantly vibrant and growing institution, and the George Mason University being one that is growing and vibrant as well, including with this brand new facility. This is one of the first programs we've been able to hold over here in Fuse, and we're delighted to showcase it to all of you. With that, we hope that you will continue to engage with the Law and Economics Center and with George Mason University's Antonin Scalia Law School and continue to support our students. Thank you for those who have been hiring them, and thank you for those who will be hiring them as a result of meeting them today. We hope that you will also be back next year for our program. But we're not done yet, and we're excited to have our final fireside chat. And so for the final segment of the program, I'd like to introduce you to the incoming editor-in-chief of the George Mason Law Review. We congratulate him for taking on that post, and we turn over the final introductions to Matt Thomas.
Good afternoon, everyone. Thank you for being here. I would like to thank Garrett Gillespie, our symposium editor, one last time for helping put on this event. It is an honor to be able to introduce our final event, our fireside chat, between Chairman Andrew Ferguson and former Chairman Timothy Muris, who I've also had the pleasure of being his research assistant for the last 6 months. And so I've been looking forward to this for a long time. So please welcome them, and I'll pass it over.
Well, thank you very much. Let me say a little bit about the chairman, and as you know, or maybe you don't, like Gaul, the federal government is divided into 3 parts, and that's what the Constitution says. And our guest today has worked in all 3. He was a clerk at the highest levels for Justice Thomas. He also clerked for Judge Henderson. He worked on the Hill in the Senate for the leader of the majority, and also on the Senate Judiciary Committee. And of course, he's now working in the executive branch, and again, there are only 3, as chairman of the Federal Trade Commission. He also worked in the states as Solicitor General. Let me start with having had a lot of jobs at the Federal Trade Commission. I think of the place as having inside and outside activities. And again, you can think about them in 3s. Inside, there's how one deals with the issues in terms of the substantive issues, the case agenda. There's also how one deals with the outsiders. And the outsiders are many. There's, of course, the administration, there's the press, there's the Hill, et cetera. And besides inside the commission, that case agenda, there's also a research agenda. Now, personnel issues, so there's outside and inside. Personnel issues and budget issues permeate all of this. So let me start by asking the chairman what his inbox was like 13 months ago. He inherited a budget that was a bit of a mess with a lot of last-minute lawsuits also filed by the administration. He took over the reins at the very, very beginning. And so what was in your inbox, Mr. Chairman?
Well, the most important thing, well, before I answer that, I'm really pleased to be here at Scalia Law School. I actually taught here for a couple semesters. I taught Fed courts and conflicts, and had just really outstanding students in my class, including, at the time, future Supreme Court law clerk. It was very obvious that she was going to be able to do that from her performance in the class. And because there was just a pitch to hire Mason students, I have hired Scalia students at very senior levels at the FTC. My principal competition advisor is an alumna of this school, and my head of the Bureau of Consumer Protection is an alumnus of this school. So I agree it's a good idea to hire graduates of Scalia Law. So the most important thing in my inbox was confirmation from the Executive Office of the President that the President had signed my appointment as chairman. There was a sort of brief period where the outgoing chairwoman who lingered in the commission for a little while after Inauguration Day was still in charge. I then, after having that confirmation, had to implement my succession plan. The outgoing chairwoman had her succession plan of people to be the acting folks in various offices, which was not consistent with the one that I then implemented almost immediately. And then I had been a minority commissioner for about 9 months before then, so I had a sense of the budget crisis that I was inheriting, but not as good a sense as I got within the first 72 hours. I'll talk about the budget crisis a little bit, but also the outgoing administration, there wasn't really a budgeting culture, which I'll talk about in a minute, but the budget crisis was sort of straightforward. First years of the Biden administration, Congress pretty substantially increased the FTC's annual appropriation. Second 2 years of the Biden administration, they brought it back to sort of historical levels, but that was a substantial decrease from the previous 2 years. During the first 2 years, my predecessor went on a hiring bonanza. A hiring bonanza that once accomplished could not have been sustained at the subsequent appropriation level. So when I was a minority commissioner, I would have meetings with the CFO, who was a phenomenal, longtime military guy before he became CFO, and just sort of the idealized version of the civil service was embodied in my former CFO, just a great American. He would hint when I was minority commissioner that if we don't get the payroll under control by 2026, there may have to be some furlough decisions. And then when I became chairman, he said very straightforwardly, if we don't get the payroll control, basically in the next 9 months, we will have to start furloughing people. We cannot afford present employment levels. And so the first thing I had to do was say, I don't want to furlough a human being at the agency. It's terrible for the agency. It's bad for our cases. It's bad for being able to hire in the future. When I was a law student during the financial crisis, a very prominent national law firm basically laid off its entire first-year class. Latham and Watkins, great law firm. But people my age had a term called Lathaming. And for a long time, people were afraid of going to Latham because of what had happened to that infamous 1L class. And I was like, look, if the FTC gets a reputation for furloughing, when I am able to start hiring again, who would want to come here knowing that I may cancel your paycheck? And so I said, we need to figure out ways to cut payroll in a way that doesn't involve furloughing people and get the rest of the expenses under control. And sort of fortunately, from my perspective, the administration undertook the delayed resignation program, which basically allowed me to put people on administrative leave for several months, and then they could depart the agency, but they could continue to collect a paycheck. It was like a departure incentive program. So we offered that twice. We got permission from the government to offer early retirement, and we got the payroll to a level where we could continue our work and begin hiring at a sort of regulated, monitored clip, no matter what Congress did with our budget. And what Congress ended up doing with my budget a couple weeks ago was slashing it by about 9%, which in the situation that I inherited, if that had happened, this would have been basically existential for the agency. But because of decisions we made early on to get the budget under control, we're ready to absorb it. We are hiring for, I think, something like almost 100 positions. We've hired, I think, like 50 of those 100, and we can continue that clip consistent with Congress's new appropriation because of the very tough decisions we made early on. The other thing, which ended up being one of the hardest sort of non-substantive enforcement challenges at the beginning, was that our lease, the FTC has two buildings. We have our historic headquarters kind of right in the middle of the Federal Triangle, and then we have rented office space across the mall in a commercial building. That lease had expired some time ago. I kept, in my meetings as a minority commissioner, I kept being told by the career financial staff, like, we need to do something about this and it'll be expensive. We're not saving any money. Hopefully we can sort of survive this. And a couple weeks into my time as chairman, we were told, you're being evicted from the building and you need to do it in 100 days. I actually found out about this in a meeting where it was my first meeting that I called to decide what to do about this building. We just got like an email that was like, you need to be out in 100 days. We maneuvered, worked with the admin, basically got that delayed, then began a pretty intense search across Washington to find a new space to move the people that were in the office space rather than our historic headquarters, which is about half of the DC-based agency. Found space, we're gonna make it work. Honestly, thanks mostly to the incredible work of the career administrative staff who really just knuckled down and helped us do it. I understood that these were issues that the leader of the agency has to deal with as a minority commissioner. I didn't really understand what that meant until the gavel switched hands, and all of a sudden meetings that were basically like, FYI about what's happening at the agency were, FYI, here's what's happening at the agency and you need to do something about it like right now. And if it doesn't go well, it's gonna be entirely on you. And so, first 4 months, trying to get a grasp on that, make decisions with imperfect information, while also assessing all of the things that I had inherited from the previous administration, but particularly things that they had done since the morning after the election. It was a lot of work in the first 6 months that I did not appreciate when I decided that I wanted to be chairman of the agency. Figured out pretty quickly, weathered the storm, got the agency through, and I'm very happy about the agency's trajectory now. But the first 6 months, I think the first 6 months of taking over any organization of any size are hard. I think all transitions of government are hard. I've never heard anyone that worked on a presidential transition or worked early on in any agency of government that did not describe it as difficult. But we were getting clear direction from elsewhere in the administration about the president's priorities, and our job was to make sure that worked within the agency.
Thank you. Let me ask another general question, and you're one of the few people, I suppose Chair Khan could have answered this as well. She had a period where there were no Republican commissioners, and then you and Melissa were there for a while. But now you serve without Democrats. What's the difference that you've seen, if any, between the time that the commission had multi-party and now?
At least from my perspective of assessing the sort of before and after the multi-party membership as chairman, I don't see any difference really. I mean, I have a vision for what I want the agency to be. I'm also, I serve at the pleasure of the president, and I'm a principal officer within the executive branch headed by the president. And so I have an agenda set by the elected head of the executive branch, for the whole government. And then my job is to make sure the agency is implementing that consistent with the laws that we enforce. And that would be true no matter who was at the agency. So from my perspective, no real difference. Look, I mean, Melissa, of whom I think the absolute world, and I worked with when she was SG of Utah, and she is going to be the most fearsome I think the most fearsome U.S. attorney in the federal government out in Utah. During our 9 months at the commission, we wrote hundreds and hundreds and hundreds of pages of dissents. In fact, I think at one point I calculated she wrote 480 or something like that, and I wrote 370. But I mean, it was an incredible clip for 9 months. A lot of that is the fact that they tried to launch God knows how many cases in the final 2 months of the administration once the presidential election had been decided. But our output was voluminous. The former Democrat commissioners had been there for many years by the time that the president removed them, and a tiny, tiny fraction of it, including one of them in the minority, had written a tiny, tiny fraction of that. And so my view is that my life has not meaningfully changed. Both while Melissa and Mark were there, and now when Mark is there, the three of us have different views on the direction the agency should go, the types of cases we should bring, the types of things we should plead. Do we agree on more than we disagree? Yeah, absolutely. But we don't have perfect alignment. And I can tell you from having been in closed commission meetings with the two of them, that the debate we would have on whether to bring a case, how to contemplate, potentially undertaking a rulemaking was very, very vigorous, because the three of us don't see eye to eye on everything. And sort of, the testing by fire of having multiple points of view, in my experience as chairman, was extremely true when there were three of us even of the same party, because the three of us have different views on priorities, different views on, the meaning of very generally worded statutes. And when you are at a law enforcement agency, the debate over priorities is half the battle, especially when you've got a $388 million a year budget like I presently have. The priorities debate is super, super important. And my views were constantly tested by discussing them with Commissioner Metter and with Commissioner Holyoke. And frankly, I think no differently or more intensely than they would have been with other commissioners there.
Before I turn to some questions about the case agenda, talking about that you serve at the pleasure of the president and talking about the difference between the parties, you talk about the Trump-Vance FTC, and some people have found that odd. I find the criticism odd in the following sense. Your predecessor, one of the first things that she did was at the White House stand by the president when he issued a competition executive order giving which I think there's nothing wrong with this, giving the FTC directives. And it was also something I did think there was something wrong with when he criticized the previous 40 years. When I was, the most visible thing that we did when we rolled out the National Do Not Call Registry, we rolled it out in the Rose Garden, which is about as close to working with the administration as I think you can get. But so if you would comment on that criticism.
Yeah, so look, I was raised within the conservative legal movement. I'm a law clerk. I was a law clerk to Justice Thomas. The talk of there being three branches and only three branches, and every part of the government must fall within one of those three branches, and that there isn't a quasi-legislative, quasi-executive, quasi-judicial fourth branch, I had imbibed and fully believed when I became a minority commissioner and when I was chairman. And so I wanted to make it clear internally and externally early on, there are no independent agencies. The Federal Trade Commission is part of the executive branch. We just had an election about who's going to be in charge of that executive branch. The people voted for one candidate over the other, and we serve within that branch, period. We aren't independent. We don't get to make up our own minds all the time on everything. We do not answer only to ourselves. And I had written extensively about this as a minority commissioner. I wrote a dissent as a minority commissioner where I argued that two-layer protection for FTC ALJs was unconstitutional, a position that the administration now shares and has ordered agencies throughout the government not to defend two-layer removal protection for ALJs. But this thing that I think for a lot of people was sort of theoretical, the idea that there are only three branches and that every part of the government must fit within one of those three branches, was for me very, very, very real. And so when I took the helm of the Federal Trade Commission, I wanted to make it very clear, we are part of the executive branch, period, full stop, end of discussion. and that I serve at the pleasure of the president, and that our job is to execute the laws of the United States over which Congress has given us charge consistently with the agenda set by the man that tens and tens of millions of Americans just voted to become president of the United States. This became very real for the whole country when the president began to remove commissioners and board members from commissions and boards that had claimed independence. I attended the arguments in Slaughter against Trump. I have learned, both as a former Supreme Court practitioner and as a law clerk, that it is very, very stupid to predict Supreme Court outcomes on the basis of the conduct of oral arguments. But suffice to say, I feel extremely confident about the outcome of Slaughter against Trump, and particularly given the fact that even the respondents in Slaughter against Trump declined to defend Humphrey's executor on its merits. There is universal recognition that the contents of Humphrey's executor cannot be defended, and that insofar as we're going to have independent agencies, we need a new rationale, and that what the court said in Slaughter just doesn't exist in the real world anymore. But I feel quite confident about the outcome of that case, and that is just consistent with my view that independence in government is just anti-democratic. I need the whole premise of our constitutional structure outlined by Madison in the first debates in the 1789 Congress is that there must be a chain of dependence running from the meanest officer of the government back to the people, and the only way that that runs is through the president. And pretensions to independence are just categorically anti-democratic, and that treating the FTC like it's part of the executive branch is restoring democracy to the executive branch.
Let me turn to what I call the enforcement agenda. There's a lot of discussion today about the economy, and a lot of it goes under the heading affordability. The FTC has always talked about what we now talk about affordability. They might have called it pocketbook issues. Let's start with consumer protection. A distinguished alum, as you mentioned, is with you today, who's the head of that bureau. What about what you're doing there implicates affordability?
I agree with you. Chris Maffarge is one of the finest lawyers that I've ever worked with and runs our Bureau of Consumer Protection. I've always described the two roles of the agency as, our economic system depends on vigorous competition, on a sort of like low-grade war among market participants to compete for consumers, compete for dollars, compete for feet to come into the store, et cetera. And that our consumer protection rules are like the Marquess of Queensberry rules for boxing. We want you guys to fight, but we are going to impose limits on everything, on what you can do to compete. And those limits include, you can't lie to people, you can't mislead them by omission or commission, and then the slightly more complicated part of our law is you can't treat them unfairly. And on the consumer protection side, sort of enforcing those rules about how competition is supposed to proceed. I've seen it as my role to try to restore people who have money wrongfully taken to out of their pockets back to where they were. And that the goal here is not press releases about corporate wrongdoing. It's finding people who are hurt, going after the people who hurt them, and taking the money that was put into their pockets wrongfully and putting it back into people's pockets, and sending a signal to the marketplace that if you do this type of thing, you're going to hear from us. And if you broke the law, I'm going to come get you. And so our rate of case development has been just spectacular. I mean, I will put the intensity of my enforcement agenda up against anyone of either party from the last 50 years. I think the difference between me and my predecessor is I am not trying to pursue grandiose market remaking theories of consumer protection, and that the goal is find people who were hurt and deliver to them, and find the biggest groups that you can and deliver to them the results as quickly as we can. But only bring the cases that you think you can win. I mean, one of the things I told staff very early on was, I've noticed a difference between cases that you think you're going to litigate and cases you think you're going to settle. And when you bring me cases that are settling, and I sort of poke and prod at the evidence, sometimes it's a bit lacking. And if it's cases that you're going to have to litigate, you built them up a little more. I'm not going to settle cases I don't think that I have a chance at winning at the stage that we would bring it, just because we're going to settle. In other words, I don't want to do this like extortionate thing where you hit someone with the CID and they say how much they have to pay you to go away. I want to go after people who have actually wronged people. I want to go after people who sort of leak money out of consumers in ways that they don't necessarily notice at the time, and restore those consumers to their rightful place, and to restore trust in the marketplace. I mean, I think we do have, pardon my language, but there is this phenomenon that appears sometimes in newspapers, sometimes in magazines, and a lot online, called enshittification, where people sort of feel like all the time things don't work in the economy like they used to. I have to pay all sorts of drib and drab fees here and there for all sorts of stuff I didn't used to. Things don't go as well as they used to, and it's very frustrating. And I see it as one of my most important jobs is to get people confident in participating in the market by making them believe that when they participate in transactions, they know what they're getting into, nothing's going to be taken from them unfairly or unwittingly. And that sort of confidence makes people more willing to participate in markets and keeps economic activity going. And so we've brought a lot of ROSCA cases, big ROSCA cases involving online commerce. The rate of frustration that I hear from consumers about fees tacked on at the end of transactions, misunderstanding about what they were signing up for when they were signing up for. I mean, there's a reason Congress passed this law, but given how much commerce takes place online every day, we've really focused on bringing strong ROSCA cases to try to promote some confidence in the marketplace. And as we've announced, we are exploring a click-to-cancel and negative option rule, a lawful one this time. But again, as part of our goal to try to make people confident in the markets in which they're going to participate, encourage them to engage in economic activity to keep the economy going.
You mentioned money, and you have been getting a significant amount of money back despite the AMG case, of course, which said that the Commission's use of 13B, especially the way they tried to expand it starting in the Obama years, was not justified by the FTC Act. But given AMG, what are the obstacles and how have you overcome them?
That's a good question. And for those not, Tim is very familiar with this because he was in my shoes once. For those not familiar, there's a provision of our law that says we can get injunctive relief against parties. And beginning back in the 70s, the Commission began to interpret that as including injunctive orders for monetary relief. That proceeded for a very long time, and then a couple conservative judges in the lower court started to say, we don't typically interpret the word injunctive relief to include orders for money. That's normally like a remedy at law. And in 2020, I think it was, 2021, it made its way up to the Supreme Court in this case called AMG, and the court unanimously, in an opinion by Justice Breyer, the most vigorous defender of the grandest version of the administrative state, said injunctive relief doesn't mean orders for money. The difficulty for the Commission is that the main way that we had been getting money wrongfully taken back into consumers' pockets, as opposed to like civil penalties which go to the Treasury, was this provision. There is no provision in our law for me to bring a plain statutory violation complaint against a party and get money taken pursuant to that statutory violation back into people's pockets. If I bring a naked Section 5 case, like a brand new Section 5 case against a party, and I win, there's nothing in the law that allows me to get the money that they defrauded people from and put it back in consumers' pockets. The way that we do that is I can do it if they previously violated Section 5 and I'm hitting them for the same thing. That actually doesn't happen that often. Or if they violated an FTC rule, I can get civil penalties. So we bring a lot of rules violation cases so that we can get civil penalties. But the other thing that we started doing a lot of, and the previous administrations did this too, but we do this a lot, is we have state partners. And our state partners generally have baby FTC acts. But most baby FTC acts have provisions authorizing civil penalties for ordinary statutory violations, and a lot of them have provisions allowing for consumer relief. And so we will partner with our state allies, both parties, and bring cases together so that even if I have just an ordinary Section 5 case, my state partners are coming in for money. And the FTC has a system built in for many years by people like former Chairman Muris, where we can deliver relief recovered in cases to consumers more effectively than almost any other agency of government. We can find out who was hurt by something and get money back in their pockets. And so we then assist the states in getting money back into consumers' pockets. It's one of the value adds we present to the states, along with having the best consumer protection lawyers in the country. So on the consumer protection side, that's how we've tried to build a system where we can continue to get money both for consumers and civil penalties, is lots of rules violations cases and lots of working with states. But I will be honest, I have been urging Congress since I became a minority commissioner to adopt an amendment to the FTC Act that would give us the power that the commission believed, incorrectly, that it had under 13B. And they can put whatever guardrails on it they want, but it isn't a really important tool that the commission needs to be able to sue a fraudster for violating Section 5 and get the money they took from people back into those people's pockets. And I think we need the direct approach that we used to have, which is just a statutory provision. I also think there are other amendments that probably ought to be made to clarify parts of the FTC Act. For those of you who aren't aware, there is a constitutional challenge to our internal adjudicatory authority pending in the Fifth Circuit. It's been pending there for like 15, 16 months or something like that. But the challenge, if successful, would foreclose lots of our we call them Part 3 because that's the part of the chapter of the CFR in which our internal adjudication rules appear. But there are ways that the FTC Act could be better written to clarify when and under what circumstances and what relief is available for us to go directly into federal court rather than using our internal adjudicatory procedures. And I think after Jarchese against SEC and various other challenges to other parts of the government's power to do internal adjudication, that some clarification there would be helpful too. And so my view is, if we're gonna do something on 13B and giving us authority to get relief for consumers for Section 5 violations, we ought to at the same time clarify our authority to go directly into federal court, because I think the handwriting is sort of on the wall for the grandest version of agency adjudications.
Let me turn to competition, and do it with a case that especially was pled as consumer protection and also sort of straight unfair methods, and that was the case involving Express Scripts that you settled, and it did get a lot of publicity. I wonder if you could talk about that settlement.
Yeah, so this was a case that was voted out in the previous administration, but my recollection is it was unanimously by a then bipartisan commission, accusing the three major pharmacy benefits managers of both an unfair method of competition and unfair acts and practices in the rebating system they had for insulin. I am going to spare all of us, including me, attempting to explain in anything approaching like a 15-minute lecture the PBM rebating system. But this was a case that was proceeding in the internal, within the agency's administrative adjudication authority and had been pending for some time. This was one of the most curious features of the entire FTC to me. Because Chairman Muris had been an FTC guy before he became chairman, this probably didn't surprise as much as surprised me, but when I became a commissioner, there's this rule, the commission votes to bring cases within its internal adjudicatory system. Once it does, so we are the investigators and prosecutors, and then once it does, a quote wall, end quote, goes up between the agency lawyers that are gonna adjudicate that case and the commissioners who the second before were the prosecutors and are now the judges. And we are suddenly forbidden from conversing with the people who are going to prosecute the case in any way. And so what that ends up meaning is if a party comes and wants to settle, they can't negotiate it with the head of the agency. They have to negotiate it with staff, with the head of the agency entirely in the blind, until staff have concluded that it's a good enough settlement to at least present it to the agency. And then they vote to bring the wall down, and then we can talk about it again by removing it out of adjudication. So, this was negotiated originally between staff and ESI for a long time. Then the wall came down, and we did some additional work on it. But it's a pretty comprehensive settlement involving ESI's business practices that aren't just limited to rebates and insulin. It requires them to change a lot of their business practices with regard to community pharmacists. It requires them to give a standard formulary offering across the board, rather than trying to offer bespoke ones to all sorts of people who might not be sophisticated and know that there's sort of a standard one that would work best. And I'm going to be relatively vague about this because it's still out for public comment. You all are welcome to comment if you want. The ESI is returning its GPO from Switzerland to the United States to the tune of about $75 billion a year of economic activity currently in Europe coming back to the United States. So it's a big deal. It required an incredible amount of work from FTC political and career staff. And again, this is just an example of the FTC sort of just rowing in the same direction as the administration. You said it earlier, you can call it pocketbook issues, you can call it affordability, but the most consistent thing I hear from consumers, every consumer, is healthcare costs are too high in every single part of the healthcare chain. And so we, on both sides of the House, have focused intently on bringing cases involving the healthcare markets. This is one I inherited. But I am particularly proud of the settlement, which again is still pending for public comment, because once it is fully operational, this is going to restore billions and billions of dollars to plan sponsors and to consumers, and rationalize a marketplace that has become extremely complicated, not just for consumers, but even for people like me who are regulating these marketplaces.
Thank you. Let me turn to mergers. I wanted to ask a couple of questions. Your predecessor, and this was also true in the Justice Department, seemed to have an aversion to settling. Why don't you let us know what your view is on that and why? So at least my predecessor had a oft-repeated aversion to settlement, but although it was honored more in the breach. I mean, they settled cases, including some pretty difficult to justify settlements involving oil companies right at the end of the previous administration. But the DOJ, for example, had a categorical objection to settling merger cases. And by settling merger cases, what I mean is commission either says that they think that a merger is likely to violate the antitrust laws, or in fact brings a complaint alleging that a merger violates the antitrust laws. And you could get an injunction in those circumstances if the agency is correct categorically forbidding the merger. But sometimes there's like a lesser remedy that can equally protect competition, that can involve divestitures, or I think appropriately less often, a behavioral remedy where a merging firm agrees not to do something in the future. And that is often by far the optimal way to protect competition, because I can tell you that every case, merger case, conduct case, is extraordinarily expensive. Even the ones that we have done quite efficiently are a couple $1 million, and involve tremendous amount of manpower and other agency resources. And so if there's a way, short of a lawsuit and the many months, man hours, and millions of dollars that entails to protect competition, I just don't see any reason why it shouldn't be on the table. And the other advantage to my view, which is, yes, I am open to settlements. I'm not going to do fake settlements. I'm not going to do settlements that require me to do all sorts of monitoring for many years in a way that I could never actually ensure that the merged firm is complying with what we told them they had to do. But I'm open to divestitures. I'm open to negotiating. And I think that the openness is important, because what I don't want to happen is for merged parties to negotiate some sort of bad divestiture before they get to the agency without the agency being able to weigh in and make an assessment about the adequacy of the assets being divested, the adequacy of the buyer, other protections, et cetera. I think making it clear that I'm willing to do real settlements that fully protect competition means that the agency can lend its expertise to the process. And so we have done some divestiture packages. We've done a behavioral remedy too. I remain open to them. I'm also very sort of clear-eyed about the risks of divestitures and how we need to treat
different types of divestitures differently. For example, there is literature out there already, and there is emerging literature that I have access to that suggests that divestitures in retail cases and in grocery cases in particular are very, very, very difficult. It's hard to get the right asset package that will actually maintain competition once the divestiture is concluded. It's hard to get the perfect buyer, whereas in like pharmaceutical mergers, for example, it's actually a much higher rate of success of divesting particular business lines or particular assets if you can find the right buyer. And so, as I think about settlements, I think about settlements in slightly different ways. If it involves retailers and grocers, I'm going to require more from the parties to convince me that this actually will protect competition fully in the absence of a lawsuit. And when it involves lines of businesses, I'm more open to those if I'm convinced that the buyer is really going to be able to make it work, and that the line of business being divested can stand on its own in the hands of the new buyer. So yeah, we're doing them. We continue to be willing to do them. And I think that that's an important tool in the agency's toolkit, because otherwise, the only thing I have available are lawsuits, and I have a pretty limited number of those I can bring. I'm willing to bring them. I brought 4 last year. I'm more than happy to do this, but there's a limit to how many I can do. I have manpower limitations, I have money limitations, and if I can restore and protect competition without having to undertake the expense of litigation, it ought to be on the table. I think the reason that the previous administration was willing to keep it off the table was that the primary tool that they used to slow down M&A work was that they just made the merger review process the punishment. And that the goal, they recognized that they couldn't sue everyone, and that even people that they sue, they often lost against. And so rather than undertake that, the alternative is you grind down mergers in a process that becomes convoluted, confusing, and endlessly time-consuming, and that will disincent mergers, and so people just won't merge. And if the goal is to sort of have a command-control economic version of antitrust, that's the easiest way to do it. I don't want the process to become the punishment. I don't want the process to become an unnecessary cost. But in order to make sure I'm adequately protecting competition, settlements have to be part of the calculation.
Thank you. Second merger question. You brought a case recently where you did not follow the normal Hart-Scott PI Part 3 process. Why did you do that, and will that be the norm going forward?
That's a great question. That gets back a little to what I mentioned earlier about what jarcossy and other Court of Appeals opinions portend for the FTC's ability to conduct internal adjudication. So the ordinary approach up until me in merger cases was you file an administrative complaint. This is also contemplated by statute. It's not like they were making it up. This is contemplated by statute. You file a complaint within the agency alleging that the pending merger violates the antitrust laws, and then you ask a federal court to preliminarily enjoin the merger pending the resolution of the agency complaint, of the agency adjudication. As a matter of fact, the preliminary injunction litigation ends up being sort of the end of the question. For in almost every case, especially over the last 25 years or so, if the PI goes in the government's favor, the parties abandon the merger. They don't wait for us to actually litigate the internal adjudication. And 9.9 times out of 10, if the agency loses the preliminary injunction, they abandon the adjudication, because as soon as the PI is denied, they can consummate the merger. And unscrambling the eggs is exceedingly difficult, because even if we conclude that the merger was unlawful, and that goes to a court for judicial review, and even in a world where a court agreed that the agency was correct, that the merger violated the laws, there's a second question in equity about the right thing to do after several years of the merger already having been consummated. Jarcossy, I will spare, also this is like the center of admin law for the East Coast, so you guys know jarcossy probably as well as I do, but jarcossy has language in it suggesting that in private rights type cases, even if the government is not extracting a civil penalty or other monetary relief, you can't proceed in an agency adjudication. It has to go to an Article III court. I see that. I see other challenges to our agency adjudication. And also the fact that our PI is generally sort of the end-all, be-all of the merger litigation question. And my view is we ought to just litigate this in federal court, both to avoid the constitutional challenges. Every time we bring a merger case, an Axon challenge is filed against us at the exact same time, arguing that our internal adjudication is unconstitutional. I eliminate Axon challenges entirely by not bringing these within the internal agency adjudicative process. And I also align the standard that the Department of Justice has to comply with in order to get an injunction of a merger with ours. If a PI standard is a little different from a permanent injunction standard, but if I'm seeking a permanent injunction standard outright, the FTC and the DOJ are applying the exact same type of law to the exact same type of legal question. And one of the criticisms that the FTC has come under in Congress is that it's not fair for the outcome in court cases involving mergers to depend on which agency you file in, because DOJ has to get a permanent injunction. The FTC was getting preliminary injunctions. Those standards are different. I honestly think that the outcomes are probably not different, and courts are basically doing the same thing. I thought that way before I was working at the agency. When I was getting a PI as a state solicitor general, if I was wrong on the merits, the PI was going to be denied. It didn't matter if I had like a colorable argument or some likelihood of success. If the court thought I was wrong, I was not going to get a PI, which is basically the permanent injunction standard. Is this the norm going forward? I think this is the healthiest way for the agency to proceed, not just for the legal reasons I just gave. I think there's a lot more credibility in the agency's enforcement when the final determiner of whether the law has been violated is not the person making the accusation. I mean, think about how this would normally go. I accuse someone of violating the antitrust laws by attempting to consummate a merger, and then I sit in judgment of my own initial conclusion. That no man ought to sit in judgment of his own case. That is axiomatic to the Anglo-American system of law. And I think that the most credible way to do merger enforcement in this country is for the government to make an accusation that the law has been violated and convince a neutral arbiter in Article 3 that we are correct. That's how the government does it in almost every other setting, and I just don't see any reason why we ought not to do it now, not to mention, as a matter of fact, that basically is how our merger cases have been going.
Thank you. Well, it's late on a Friday afternoon. I've got other questions, but let me finish with this one, and that is what surprised you. And let me give you my example and say I hope for your sake yours is not like mine, because I was chairman when 9/11 happened, and that caused me to spend a lot of time dealing with security issues, both building security and security of individual people. And believe me, I could have written any list of items before 9/11 of what would occupy my time, and those issues would not have been on the list. And obviously, they became very important. The FTC, for example, kept the doors open of the garage before 9/11, which was, not a good thing to do. And all sorts of other things. The FTC's windows were a problem, and because of what we did, they can't open anymore. But anyway, that's the most inside of baseball. So what has surprised you?
I don't have anything of sort of the gravity and tragedy of 9/11, which didn't just change the sort of FTC's physical infrastructure, it changed the physical appearance of
everything.
All of Washington. But mine are in the same sort of like area of responsibility, which is building management. I mean, the move from Constitution Center, which is the private building where a lot of our staff have been for many years, to the GAO building, which is where we're going next, has occupied an unbelievable amount of time to accomplish the move, but the incredible amount of time to prevent having been moved against our will to a building we weren't picking, finding a building, choosing among buildings, making us fit in a building, just an incredible amount of time, and was not, again, I knew we were gonna need to move eventually. I just did not realize that, as a matter of fact, that meant tons of meetings, tough decisions, site visits, contentious debates with other parts of the government that wanted us to do one thing and we wanted to do another. And then, I inherited a building that had the bacteria that causes Legionnaire's disease in the water. I mean, the combination of COVID and poor management from the previous administration, it's just a lot of sort of like daily, this thing is broken. We were getting into the water fountains to fix the Legionella, and then it turns out that the pipes behind that were also collapsing, so we need to repair those as well. And then I think sort of the last part was I inherited an agency that was basically a remote agency. I mean, when I was chairman, I was routinely the only presidential, or when I was minority commissioner, routinely the only presidentially appointed person in the building at all. Many days of the week, my staff and I were the only people in the building. And the president was elected promising to bring people back to work, and he did. But the previous administration had been hiring people for buildings in other cities where we had no offices for them and just telling them work from home, it's not gonna be a problem. Getting the agency back into the office, restoring, the FTC has one of the thickest cultures in all of the federal government. And that culture was in serious disrepair because everyone was working from home. Your colleagues were thumbnails you saw on a laptop screen, except once a week when people were in the office. And we were losing the culture that had made the FTC such a great place to work before 2021. And yeah, getting people back in the office was painful and required all sorts of tough decisions and was difficult, but and it was really hard. It was really hard work, but it was totally worth it to restore the thick culture that people like Tim had created over the course of many, many decades at the FTC.
All right, well, let's thank the chairman.
Thank you.